It's my pleasure. Thank you for the invitation, John. Ladies and gentlemen, dear colleagues, I'm going to talk about the Societas Europaea, or to use the abbreviation VSE, the European Stock Corporation. And my question is whether this legal form is fit for multinational enterprises. So you can see my outline here on the first slide. I did a handout, but I'm afraid that wasn't copied to you, so no problem. You will follow my lecture also by my slides. Ladies and gentlemen, the Netherlands and France are still arguing who is the founding father of the Societas Europaea. Already in June 1959, on the 57th annual Congress of the Notaries in France, the notary Thiberge developed the idea of a European company that is only governed by the European law. Only some months later, in autumn 1959, the Dutch law professor Peter Sanders developed in his inauguration lecture the same idea without knowing about the speech of Thiberge. So again, there was this idea to develop a company that is only governed by the European and not by the national law of the member states. Outside the Netherlands and France, however, we say there are at least two founding fathers of the Societas Europaea, although Peter Sanders was more influential because he was the chairman of the first study group in the early 1960s who developed ideas how you could bring this idea to life. And that Peter Sanders was more influential, you can see on my slide, I was only able to find a picture of him. He's here in his late 90s, sitting on a chair around a lot of books like a good law professor is doing. But Mr. Thiberge must have been an important person as well. At least his law firm is still existing in Paris. Now, I'm not going to bore you with any more details of the history of the Societas Europaea, but important for our discussion today is that we had a first draft in 1970 that was a fully harmonization and a fully codification for the European company law. But this does not came in force when UK entered, not left, the European Union when discussion had been more complicated, when we had a couple of other drafts in the 1980s, and in the end of the day, at the Prime Minister's meeting in Nizza in 2000, in November 2000, there was an agreement, but this agreement was a compromise, like always in Europe. The last draft for the regulation that came in force had only 70 articles. And so many of important questions, for example, like the law of corporate groups or many rules on the shareholder meeting had been left out. Everything where the member states hadn't been able to agree on, they just let out, and they did the following, as you can hear on my slide. They make a reference to the national law where the Societas Europaea is located. That means that we have a quite complicated structure of legal sources for European company or stock corporation. You can see here on my next slide. So first of all, you have to look in the SE regulation, and hopefully you found something there. There are a couple of rules, especially for the foundation. But many questions are not solved in the regulation. So now you have to look in the national law of the state where the SE is registered. So and now when you have to look whether there are special laws for the SE in this country, for example in Germany we have a special act for the SE which is located here in Germany, and if that doesn't work as well, then you look in the general company law in Germany in our stock corporation code. And now the question is whether the charter can regulate questions for the SE. This depends on the European and the national law, whether they authorize the charter to do a regulation of a problem. So this is a quite complicated structure, and in the end of the day we have only a European superstructure and not a real European company because it's different where you're located. There's one company lawyer here in Germany who once said, there is not the one SE, there are 28 SEs depending on the port or the haven where they located. So now one can say, well, why should a multinational company use such a fragile European superstructure? But there are a lot of advantages that had made the Societas Europaea, at least in some countries, a success story. First of all, you get a European label. And that is quite important, especially if you do a mergers on equals. And even more important, maybe, is the psychological effect if you do a mergers on equal, because you can choose a neutral law source, the European law, and you don't have to agree on the law of one of your partners. So that is quite important, and that is helpful for mergers of equals. Then the Societas Europaea has the advantage that you can move your registered seat from one state to the other without any liquidation beforehand. And as you all know, we tried to harmonize our law in this kind, so offer all companies the possibility to move their seat, not only the management seat, but the registered seat. But that doesn't work, and we failed in the harmonization of the national law here as well. And then, last not least, and that is important for companies who are located in countries with co-determination, like Germany, you can reduce the number of seats in your supervisory board and thereby marginalize the influence of trade unions. And even more important, you can freeze in the co-determination at the level it is in the moment for the future, although under national law, if you have more employees, you would get more co-determination. You can freeze that on that level if you do an agreement on the recent level of co-determination. And that is, at least for German firms, a big advantage to use the SE. But on the other hand, there are clear disadvantages. First of all, and that is, in my opinion, one of the most important disadvantages, we have no law on corporate groups. And as my question is this SE good for multinational companies? This is a clear disadvantage for them. I will come back to that point later on. And when, as I mentioned, we have a little bit complicated structure, and you have always to look what is the applicable law in the moment, but if you do that for a while, you get used to that. Now, I told you the SE is at least in some countries a success story, and there is no reason to throw in the towel. I want to underline that with some facts. Now, first of all, the great names. There are a lot of well-known companies all over Europe who have chosen VSA. Take, for example, the airplane constructor Airbus, or the German insurance company Allianz, or the German software company SAP, or our big chemistry factor BASF, or if you like champagne, Moneux, and so on and so on. And a big French investment company here, and so on. There are a lot of companies who have done that. And now if you look how many SEs all over Europe do we have? We had in March 2,757. Today it's a little bit more than 2,800. That sounds quite good, doesn't it? But you have to know that the regional distribution of these SA is totally different all over Europe, and that a lot of these companies are not alive. I will come back to that on my next slide. So you see here where all these SE are located. Astonishingly, in the Czech Republic are the most, about 1,900 SEs. Now, if you ask how many of these companies are alive and count that by who has more than 5 employees, it's only 90. That means that most of these companies are shelf companies. Yeah. And we have the same situation in other countries. For example, Slovakia, 123, only 13 who are alive. In Germany, it's a little bit better. We have 411 in Germany and 232 with more than 5 employees. But when you see here, this group, Italy, for example, Poland, Greece, and so on, only 1 or only 2 SEs in the whole country. So it's not known. So you can say it's Czechia, Slovakia, Germany, the United Kingdom, France, Netherlands, and some other countries like Austria, where at least some European companies have been established. Now, we can live with that, but it would be helpful if we change the attractive of the Societas Europaea in other countries. Now, very shortly, because I already get the first note for the time, how can we do the foundation of an SE? There are 5 different ways. There's numerous clauses of the forms how you can build an SE. First of all, mergers of 2 different companies governed by different law from different member states, so not 2 German companies. You need 2 from France and Germany or whatever. Then you can build up a holding SE, but that never happens in practice, so I leave it out. And then what is the most important case, and that is very often chosen by multinational companies, is the formation of a subsidiary SE. You need, again, 2 companies that come from different states, or at least the 2 companies need already a subsidiary in a different state. And when they can build up a joint subsidiary, so for example, a company in Germany with a company in France want to enter in the Spanish market, they build up a joint subsidiary as an SE in Spain. When we can transform an existing public limited company into an SE, we always need a European link in this situations, and when an already existing Societas Europaea can build up another SE subsidiarity without any restrictions and any European link. Now, I would like to talk about corporate governance and the foundation of SE. And in my opinion, there's a clear governance problem during this foundation process, because the co-determination is also a compromise again, and the compromise was that you do a negotiation between the founders of the SE and the employees of these companies. And when you found a model, and when there is a before and after principle, so that the employees, for example, coming from Germany, do not lose their co-determination that they have in the moment. Now, co-determination can be negotiated. But this negotiation is done between the management of the founding firms and their employees. The participation of the shareholders is totally insufficient. So they can only say yes or no whether they want to build up an SE or not. In the case of the holding SE and the merger foundation, they have a possibility to call in another shareholder meeting to say again yes or no after they have at least read this negotiation. But they have no possibility to influence the result of this negotiation, and as you can imagine, this negotiation of co-determination can have an important influence on the structure of a company. So there is a clear lack of corporate governance, in my opinion, and in the opinion of many other German scholars. We should do a participation of at least some shareholders during this negotiation process. We tried to make this idea public. We went to Brussels, talked to the Commission, but we weren't able to convince them. And in the end of the day, there was an evolution process after 5 years in 2010. And in the end, the Commission said, well, we are going to change nothing at the regulation because it's such a fragile compromise, and so we can't change anything. Now talking about our topic, corporate governance, corporate groups and the Societas Europaea. As I already mentioned, there is no harmonized law for the corporate groups all over Europe, and there are no rules in the SE regulation for corporate groups. That means that we have to decide how we find the applicable law for the subsidiary companies. Now, one could argue that Article 9 of the SE statute, which I showed you some slides before, is applicable, and so it's the law of a subsidiary. But the majority of the scholars argue that you have to solve this problem under the international private law, the law of collision. But normally, we come to the same result, because the law of international private law says, at least in most European companies, that the law of the subsidiary where it's registered is important for the question how to protect minority shareholders and creditors. So now think about the example. There is a mother company in the United Kingdom. It has a subsidiary in Germany, in Hungary. They have codifications on the law of groups. When in Spain and France and Italy and wherever, somewhere in Scandinavia, they have no codification about different rules. So it's very complicated. There's a lot of legal uncertainty if you want to build up a multinational group with an SE, and you have high costs for legal consultation. So in my opinion, this should be changed, but in the moment, I think there's no chance to do it. My last topic I would like to talk about is corporate governance of the Societas Europaea, and this again is a big advantage to choose the SE from a perspective of a member state like Germany, because the SE regulation follows the modern approach like France did it for years and Italy does it since a couple of years, I guess. And the regulation offers two systems, the one-tier and the two-tier system. You can read that here in Article 83 of the regulation quite clearly. Under the conditions laid down in this regulation, the SE shall compromise a general meeting of shareholders, for sure, and either a supervisory organ and a management organ, two-tier system, or an administrative organ, one-tier system, and so on. Now, this sounds like a clear solution. You can choose the Anglo-Saxon model or the more German continental model. But it wouldn't be the European Union if there wouldn't be, again, a compromise. There was another country called Sweden that said, well, yeah, we have a two-tier system, we have a one-tier system, at least in theory, but we have managing directors. And we want for the SEs located in Sweden that they are forced to have managing directors if they choose the one-tier system. So they did it, Article 43, and the national law can force the SE, which is located in its own territory, to build up managing directors beside the board of directors. This is the so-called Sweden clause. Germany adopted the Swedish model because it was skeptical about the one-tier system, said, well, there's this board of directors, I don't know who's in there. Is there anybody who's talking to me to be caught, and so on. And so they forced the SE with the one-tier system to have managing directors as well. Now the question is, what is the managing director and what is his relation to the board of directors? And now it's getting interesting, and we have two models to integrate the managing directors within the board of directors. So the first model, this is this one here, is that the board of directors is only but there are only independent directors in the board of directors, and then they have a right to issue directives to the managing directors who are outside the board and control them. This is what I call a hidden two-tier system. There's no big difference. This is de facto a supervisory board, and this is de facto a managing board, at least if we have a group of managing directors, where is typically the case. Now, the second alternative is that you integrate the managing directors within the board. And now the German law concerning the SE says, yes, that is possible, but there must be a majority of the outside directors, one half plus one person, so 51%. And if you respect that, you can integrate the managing directors within the board. Okay, normally companies do that. That is the Anglo-Saxon model, so we have inside and outside directors. And now the interesting question is, from a perspective of corporate governance, can I build up a very strong chief executive officer? And yes, that is possible. We have the possibility to build up a CEO. There is no rule within the SE regulation that forbids that the leading managing director is also the chairman of a board. As we all know, this is a governance problem. As we know from Enron and so on, that wasn't a good idea. But even worse, ladies and gentlemen, the chairman may be granted the right to make ultimate decisions overruling the majority of the managing directors. The German legislator forbade that for stock corporations with a two-tier system, and the management board has a chairman, but he does not have the possibility to overrule the majority of his colleagues. In the SE, this is possible. So this is no good example for good corporate governance. I think we should change that. But even the German code on good corporate governance does not have a rule for this and say, well, it is no good idea. We have to talk about this more in the future. As my time is running out, there's coming the stop sign, I'm nearly done. I want to do at least in conclusion. Overall, ladies and gentlemen, the SE is fit for multinational enterprises. The missing law of corporate groups is a legal obstacle. However, this problem is more a general problem of a European company law than a particular problem of the SE. There are a lot of things that the European legislator could have done better. I mentioned 2 examples, but in the moment, after the wasted opportunity in the evaluation process of the SE, there's no hope that the European legislator will do that. A brief perspective, ladies and gentlemen. There was SE little sister called the Societas Europaea Privata. It was designed for small and medium-sized companies. It would have been a good idea to build up and to structure a multinational group, but this idea, there was the first draft in 2008, is dead in the moment. Then there was a very hybrid construction called Societas Unius Personae. How shall I say it? A construction, a single one-person company governed by the European law but built up under national law, something like a hermaphrodite. We don't know that, and this idea is dying at the moment silently and rightfully so. So the SE is the only supranational legal form for multinational companies in the moment, and to my opinion for a long time. The improvement of the SE regulation is an ongoing challenge also for the next generation of European company lawyers. However, as we have learned from the history of the SE, European company lawyers need to be preserved and patient. Thank you.